I'm here with Joellen Meckley, who's a New Jersey estate planning attorney. First of all, Joellen, thanks so much for joining us and agreeing to write this guide for the site and sit down and talk to me about this subject today.
My pleasure. I'm happy to be here.
And then, second of all, just as by way of introduction, I think that this estate planning content ties in nicely to the content we have on our site. As people can see, we have a great deal of senior living, in particularly nursing home related content, and we're also going into a lot of detail on Medicaid planning to pay for long-term care. And all of those areas, I think, in the bigger picture, really tie into estate planning. And there's certain elements, of estate planning that really should not be overlooked in the context of some of these other decisions. And I sort of believe that it should be handled more holistically. I'm just wondering if you could just start out by just going into a little bit of detail about what you do and what your firm does, and sort of, also how it fits in here.
Sure, I'd be happy to. So I'm a partner at Begley Law Group. We're located in Morristown, New Jersey, in southern New Jersey outside of Philadelphia. And we are truly a boutique law firm. We're not generalists. We focus our practice on a few distinct areas, namely estate planning, estate administration, elder law, and special needs planning. So it's kind of focused around things that happen later in life. Instead of it necessarily being one subject matter in law, it's more oriented around the client themselves, kind of the different issues that an older adult is facing or someone with disabilities, what they're facing.
And it seems like in most areas of law, that's really the best way to do it. It's very difficult. Like, it's easy for a lawyer to say they have a specialty or pick some niche area, but it's much more difficult to sort of apply that to a client, because oftentimes, based on circumstances, there's sort of this basket of services that a person needs. And if a client who's going through this phase of life, if they don't find a firm that has the capacity to provide all those services, they're going to either end up having to hire multiple attorneys to handle the same task, or a lot of times what ends up happening is they get bad advice, frankly, from somebody who's sort of going outside their comfort zone.
Sure. I mean, we have people come in who say, when they call up and make the appointment, they're saying, I need to have my will done. I need to have an estate plan done. Well, once they come in and we actually sit down and meet, we start finding out that, they have an adult disabled child who still lives with them. And guess what? They had a stroke themselves last year and had a short stay in a rehab facility. And they're also worried about long-term care and so on. And it starts this cascade of things. So now we're digging into what are the family dynamics, the family situation. What's their living situation at home? What are their care needs? And here they thought they needed a will,
Right.
They come in and it's like we treat the whole person, the whole family. So
it's the classic case of a person doesn't know what they don't know. And, sometimes the only thing you can really market your services to, whether, it's online or whatever, is sort of the need that the person knows they have. But then once they get into your office, you find that, they actually maybe don't even need that and they need something else, or maybe they need 4 or 5 things. And that, it's just really great that you guys are able to, address this from so many different angles. Now, just getting in a little bit into the estate planning documents here. What are the basic estate planning documents that are going to be included in, all or virtually all estate plans?
Sure. So when I'm explaining this to folks, to potential clients, I usually describe it as being an estate plan is like a 3-legged stool. You need these 3 legs. If you only have 2, it's going to tip over. It's not going to be balanced. So one leg is needing a will or a trust, or sometimes both together, but that's one side. Then you need a healthcare proxy and living will, so a healthcare decision-making tool. And then you need a general durable power of attorney or a financial power of attorney. And those are your 3 main components of a well-planned estate.
Right. And that makes sense. And so you touched a little bit on wills and trusts. And I sort of think of these as sort of 2 sides of the same coin. The primary purpose of both, obviously, is to transfer, provide a mechanism for transferring your assets to your heirs. In some cases, obviously, the trust is unnecessary and you can just simply use a will. But what are sort of the common situations where where people should be considering a trust or where they might need one?
Sure. Well, I mean, and the main difference, and I should also say, and this happens in our own practice a lot, sometimes the trust is actually embedded within the will. So it's something called a testamentary trust because it's not a standalone document. It's part of your last will and testament. So in any situation, the only reason why you're going to create a trust in the estate planning context is because you have some sort of asset that you wish to exercise ongoing control. Not meaning you yourself, because if this is your document, you're gone, you're out of the picture. So this is for the beneficiaries, whoever's going to benefit in the future from that asset for various different reasons. You're going usually with the mindset of protecting that person, protecting maybe the asset for future generations. A trust is going to name, there's two key roles in a trust. You're going to name the trustee. This is the person who on an ongoing basis, either indefinitely into the future or for a specified period of time, is going to have control over that asset. They don't own the asset and maybe they can't benefit from it, but they have the control over it. And then the other key role is the beneficiary, is the person who benefits from the trust. And it can be multiple people sometimes who benefit from the trust. But the most common reason, like I said, is usually protection. I will do trust sometimes even for young families. I know you and I have spoken about how we both have young children.
Right.
God forbid, something were to happen, to you and your spouse at the same time, and you've got 3 young children. Hopefully you've got a nice insurance policy, some savings in the bank for them, and hopefully you've got some money set aside to take care of them and get them launched in life. Well, if they're 5 years old, they can't manage their own money. So in that situation, you could have a will that includes within it a testamentary trust that's set up for your children that says, okay, everything I own at my death is going to go into this trust for them. Maybe I'm going to make my brother the trustee because he's really close to my kids and knows them. And he's going to have authority over the money until they turn 30 years old, because I know I was pretty responsible by the time I turned 30, and I think my kids will be too. At 30, if there's money left, they can handle it. But up until then, someone else holds the purse strings. That's an easy example of a trust.
Yeah. And so it seems like the fundamental difference is just simply the timing of when they get the assets and the level of control they're going to have. And, you touched on that. And then sort of the other angle I think sometimes people use trust for that I was interested in is, what about the situation where I have I have a child or a grandchild that's already 30 and should be responsible, but maybe either they aren't responsible spending money, or they have an addiction problem, or perhaps they just have a creditor problem. What can you do there with a trust, and how would that work?
So that is an extremely common situation that we have. And again, it doesn't. I often tell people, they come in and I make a joke. I usually tell people that I'm kind of like their priest, like they have to tell me everything. They have to confess everything to me, or else I can't help them, because that's when the stories start coming out about exactly like you said. They've got 3 kids. If someone's got 3 kids, odds are one kid's gonna have some issues. It's just the way.
Don't say that.
I know you have 3 children, so it can happen even to 4 or 2 kids. But the bottom line is that it's very common, and people don't need to be ashamed of that. And the same thing I said, you don't want to say, God forbid you have a child who's got an addiction problem. Even leaving them $100,000, I shouldn't say even, that's a lot of money, but leaving them $100,000, which is not something that someone could live on for the rest of their life. For someone with an addiction problem, it could literally be a death sentence for them.
Right.
When you come into that amount of money. So in that situation, same thing. There is no age limit. You can put something in trust for someone for the rest of their life. Same concept. So long as they don't have sole control over the money, they're not their own trustee. Maybe they are a co-trustee with a sibling or a family member. Maybe they have no say at all. They have an independent trustee. Maybe they have a bank that's a trustee because it's actually a really substantial amount of money. In that situation, as long as that beneficiary has no control over the money, you can put in something called, for example, a spendthrift provision, which is a provision that basically controls so that none of their creditors, even if they get sued, if they are in a car accident and have a huge lawsuit against them, et cetera, or get into a ton of debt, the money that you set aside for their benefit is protected. And then you, as the grantor of that trust, as the person who set it up, you can make it open-ended to say that the trustee should use it for example, for their health, education, maintenance, and support, which is very common terminology that you see in the trust. Or it can be very specific. You can say it's limited. I want to be really restrictive and say this can only be used to buy a house for them and pay for their housing expenses, or this is meant to pay for their college. and that's it. I generally lean more towards it being more open-ended and flexible, just because you can't really predict, what someone's needs are going to be. But absolutely, it is. You have a lot of tools in your toolkit when you're trying to use trusts.
Yeah, and so one situation there, those are sort of these self-inflicted issues, but there's also issues with you could have this could be frankly a spouse or a child, but you could have an heir who perhaps through no fault of their own due to a disability, either cannot or should not be managing the assets themselves, or perhaps even if they could, if it's like a physical disability, there might be issues with if you leave them these assets, you're going to disqualify them from government benefits that they're receiving.
Absolutely. That's an area. In fact, so when I mentioned earlier that something that our particular firm concentrates in is what we call special needs planning. So that's the kind of industry term for it. And what that is geared towards, there are the potential beneficiaries who are disabled have a kind of whole other unique subset of considerations that need to be taken into account for exactly that reason. One, they may have unique needs, special needs, unique needs. They may have care costs that are going to need to be covered. They may need housing support. They may not be able to be self-sufficient, right? So you're thinking about that already. But then even more importantly, a lot of times when someone is permanently disabled, whether it was from birth or they sustained an accident later in life, whatever it is, a lot of times there is a number of really wonderful, valuable government benefits that they can qualify for as a result of their disability. There's a safety net. And the thing is, though, is that many of those types of benefits have income and asset qualification limits, so that you could potentially have a beneficiary who is receiving X, Y, and Z benefit from the state or from the federal government, and then grandma or grandpa, because they love and adore them, leaves them $10,000 or $20,000 directly in their will, just names that, say, adult child or grandchild as a beneficiary, and they all of a sudden inherit $10,000, which in the great scheme of things is maybe not that much money, but as a result, they lose access to their housing, they lose access to their health insurance benefits that they're getting, et cetera. So to get around that, there is a special type of trust called a third-party special needs trust that is authorized by statute. But if the trust basically contains certain types of language and is set up in a very, very specific way, it enables folks to still obtain and continue and use all the same government benefits they were eligible for before. And that the money that's in the trust is just sitting there to kind of supplement those needs. Okay, so not replace what they're getting in terms of benefits, but to basically add to their quality of life.
Well, and I think that, that's a key point right there, because I think some people might be listening and saying, well, if the person is on Medicaid and in public housing or receiving these government benefits, then they don't need any resources. So why wouldn't I just leave my assets to my other children or grandchildren? But in reality, it's the actual benefits are pretty sparse that those programs provide.
That's exactly right. It's really essential. If you think of someone who has a really, really severe disabling interest, for example, they may need round-the-clock care for the rest of their life. And there's no way that you leaving them $100,000 is actually going to be able to pay for that care outright for the rest of their lives. But they may be able to get a government benefit that provides that care, but maybe they could benefit from a little extra. It's not government benefits that people get all outraged about, people are using government benefits. Well, the reality is they're not living the lap of luxury.
Nobody wants to be in that situation.
No one's going to choose. If they have other means, no one is going to become reliant on those benefits. So it's a balance. But yeah, that's an extremely important planning consideration if you have anyone in your life who's disabled.
That makes sense. And sort of another wrinkle here that I think unfortunately is becoming increasingly common is the situation of what we'll call a blended family. So you have spouses and perhaps one or both of them have been married in the past and divorced. Oftentimes they'll have children from those prior marriages, and then they'll have more children from the second marriage. And oftentimes these people will all get along fine in life, but then suddenly one of them passes away, and it can create some issues as to how those assets are allocated. How do you handle this situation?
Yeah, so that is second marriages are definitely now all of a sudden you've gotten into a tier where it's a more complex planning situation. And again, this is my joke about I'm the priest, you have to tell me everything applies to this type of situation, because people don't usually sit down in front of me and admit right away that this one's daughter and this one's daughter hate each other, and don't like each other, or maybe or the adult children are worried that dad's new wife is going to blow all the money if he dies first. It's complicated stuff. Right. So again, what we see is, unfortunately, we also do estate administration here. So I've also worked with a lot of families on the back end after mom and dad are gone, and there is nothing that will tear people apart more at the end of life or after a loved one has died, is when they start fighting over money. So trusts can be an excellent tool in this situation as well. Because again, a classic scenario, mom and dad or husband and wife get divorced. Like you said, both have children from prior marriages, and then they remarry later in life. Sometimes even after retirement, folks, get married and they've got adult grown children whom they've raised. And a lot of times it's a concern. Typically, I always kill the men off first. Typically, it's the husband who dies first, but again, more traditional families, it could be that he's got he came into the second marriage, with more retirement savings. He's got more money in the bank, et cetera. And he loves his second wife dearly, and he wants to be able to support her, and he wants her to be able to stay living in the house that they own together. And he wants her to be able to maintain her standard of life, but he worked very hard for his money. And he wants to make sure that his children, ultimately, when his second wife has passed away, he wants to make sure that his children and his grandchildren get that money. So in that situation, what we'll usually say is, all right, well, when you pass away, let's set up a trust for your wife that ensures that she gets maybe all the income from that trust and as much of the principal as she needs to maintain her basic quality of life. And then it will say that trust stays in place until her death. Then at her death, whatever is left goes to your children, your grandchildren, et cetera. And so then again, you can start to really customize these where you say, okay, well, are we going to make wife her own trustee, or maybe we're going to make wife and the husband's son co-trustees, because then his son is kind of keeping an eye on it and makes sure that his stepmother is not blowing through the money. And it takes a lot of kind of coordination and open communication, but there are many different things you can put in place here to make sure that doesn't happen. I've even had, and I really can't urge people to do this enough, because I've had situations where there's a second marriage and husband and wife don't do this. Husband dies first, leaves everything to his wife, because that's a typical sweetheart will, he leaves everything to his second wife, assuming and trusting that that he knows that when she dies, she's going to give to his kids. Well, then she gets married a third time. And now there is another third party that this guy never even knew is now enjoying, his assets and his money. And it's you lose all control. So trusts are typically the most easy solution.
That's like everyone's worst nightmare, right?
It is. Yeah. I like to scare people into doing the right thing.
So, how do you get this information out of people? I mean, if people oftentimes, I would assume, come in husband and wife together, do you treat it almost like a negotiation where you have each one leave the room where you can talk to each independently? Is there, what's the strategy?
Yeah, so it's interesting. I can tell you in practice, it usually doesn't come out right off the bat, although some people sit down and just lay it on the line because they've already been kind of worrying about this, and then they just want to get it off their chest. It's more often, though, that we're kind of halfway through the meeting, and then all of a sudden, the son with the drug addiction, or the concern about what's going to happen when I die, are each of the kids going to be treated separately? It comes up then kind of naturally. But it is one of those things where what I have to say to people when I'm working with a married couple, even in our engagement agreement that we signed with them, if it's a married couple, there's an additional disclosure that we have to add to it that I'll say to them, listen, you need to be honest with me now, because you can't walk out this door and husband, you can't call me on the phone after and say, Joellen, I couldn't say this in front of my wife, but the truth is that's not what I want. I want to do this. Because if I'm working with the married couple, they're both my clients. So I can't do something to the detriment of the other. So I have had other situations where I've had a husband or a wife one of them wife comes to me, but she says, my husband's got his own attorney, and they're doing it themselves. So you get every flavor of family out there, every scenario you can imagine.
Right. No, that makes sense. So what about if there's a situation like this and, and I can think of a couple scenarios where this could arise, but what if you, instead of leaving assets to somebody through a will or trust, you want to disinherit somebody?
Mm-hmm.
And this could be a child that has issues or perhaps just has sufficient resources. It could also be a situation where you have a spouse that came into the marriage with more than enough resources and you really don't need to leave them anything. They don't need the money. And it's agreed on. But I know that this is something, disinheriting an heir tends to lead to more disputes. In particular, I think it's more complicated in New Jersey if it's a spouse, because you guys have an elective share statute that requires you to leave some assets to your spouse. How would you navigate this situation, and what recommendations would you have?
So in New Jersey, we have something called the elective share, which basically says, and it's just to reframe it a little bit differently. The way that you present it is a little bit not quite on point. It's not that you have to leave something to your spouse. It's that your spouse has a right to claim an elective share against your will. So you can go ahead and try to disinherit your spouse in New Jersey. Like you can say, I've declined to leave anything to my spouse, but they automatically can immediately file paperwork and claim 1/3 of your assets. So sometimes, and again, not to jump ahead, but in the context of different kinds of planning, sometimes when we're thinking about asset protection planning for long-term care, et cetera, we will create what we call an elective share will, where we know ahead of time we want to limit with that. We want to leave the spouse something, but we want to limit it. So we will limit it to the elective share, which is 1/3. However, so that's with the spouse. That's one way you can handle it. Now, there are no other beneficiaries out there in New Jersey who can assert that similar claim against your estate. People oftentimes I've had clients come in who want to disinherit a child. They have very, very good reasons why they want to disinherit their child, but they are scared to death to do it because they think that that they're not allowed to do that their child has some kind of right of inheritance, and they don't. So what we try to make clear, however, as you said, there is a potential for a dispute. You are opening up the estate for a challenge. So we explain that to people and we say there's pros and cons to doing it. What is important, the key thing is, you don't just not mention the person. You don't just omit their name. You acknowledge, for example, this child, you acknowledge that you have this child. And you state in there that you are expressly, purposely disinheriting them from your will, because you don't want that child to come around after mom or dad is gone and say, I don't understand this will. I talk to mom on the phone every day. She was old. She obviously just forgot when she was sitting down and talking to the lawyer, but she meant to leave the money to me. So we want to make sure we know that it wasn't by omission, but it wasn't by accident. So we expressly say, and sometimes, depending on how the person feels about it, we'll give a reason for disinheriting. We don't open up a huge can of worms in the will, but we'll sometimes give an actual explanation for why they're disinheriting them. If there is a potential question out there of incapacity, if we've got fighting adult children and mom or dad thinks that one child is going to accuse the other child of undue influence or something that they were manipulating into disinheriting the brother or sister, sometimes we will make recordings. We will have mom or dad write like a supplementary letter, kind of explaining, making it ironclad, that this was not a mistake. They were not coerced into doing this. This is why they disinherited them.
Yeah, that makes sense.
Yeah.
So another wrinkle, what about the situation where, you have a family business and, for some, I imagine there's plenty of situations where you could just say, well, I've got 2 kids. I'm going to leave half of my estate to one, half to the other. That type of thing isn't going to work so well where you have a family business. And you might have a situation where just one child works in the business or perhaps just has more business savvy and more potential. You might also have a situation where you actually want equal division, but perhaps the business represents some really disproportionate percentage of your net worth. What are some additional considerations for business owners?
Absolutely. And I just literally met with a family like this yesterday. And unfortunately, it was because it was in the context of a state administration, but there was a family business and some other assets. And in that situation, only one child, was really going to be taking over the family business. So couple of different considerations. So business succession planning. If you own a family business or any kind of business, really, business succession planning should be done concurrently. That's kind of a subset of estate planning, but it has some unique considerations. So you're going to want to think about, if depending on, say you had a business and a house or some other illiquid assets, sometimes in order to make sure that one child is kind of fairly compensated for the value of this business, a lot of times there's insurance policies or insurance considerations that come into effect. Sometimes you may have other business owners involved. Maybe it's not just a family-owned business. Maybe it's dad and his brother, two brothers own a business together. Well, now dad dies and the other brothers won out and the adult child wants to buy that business, same thing, but there's no other cash in the estate. So a lot of times we're advising clients on, we need to talk about life insurance policies or other things, buy-sell agreements, other tools, because the last thing you want is for your heirs to all be kind of battling this out, because you've got a business that needs to run and needs to stay solvent and needs to stay intact. So that's one thing. And certainly it is not unusual for people who own businesses to think about balancing and control. So you're going to want to have an operating agreement. If you're leaving your business to 3 children, you want to make sure ahead of time you know who is maybe going to have a controlling interest, who is going to have more voting shares, things like that. There's a lot of complex decision-making that kind of goes into the business context.
Right. And I imagine if this isn't well planned for, you could really create a lot of bad blood between your children or your children and your spouse after you pass away, particularly if one feels like they're doing all the work and then the other is getting the same benefit or even a disproportionate benefit.
Additionally, one other point with that is another consideration is the fact, depending on what state you live in or depending on who your heirs are, you might have an inheritance tax issue or an estate tax issue if it's a really valuable business. And I have seen situations where the business is valued and now there is some sort of death tax imposed on the value of the business, but there's no free cash to pay for the tax. So I have known of situations where people have literally had to liquidate or sell a business because they couldn't pay, the transfer taxes on it. So it's something that I'm kind of horrified when people come in the office and they're like, oh, by the way, I've also had this business for 30 years and, my kids will just know what to do.
Yeah.
It's never works.
And so what about another asset, probably much more common than a small business even, is a retirement plan. More and more you see people with these with the increasing prevalence of particularly 401ks, you see people with these large retirement plans. What if any additional considerations are there in a plan from a planning perspective for somebody who has a disproportionate amount of their wealth tied up in a retirement plan?
Sure. This actually became, believe it or not, an even bigger conversation this year because there was a law passed by Congress that went into effect in January called the Secure Act, which totally changed the way that retirement plans can be devised at death. So a couple of considerations. Number one, what I tell people is no matter what you do, make sure that you've got beneficiaries named on the plan. I have had estates where someone, for whatever reason, just never got around to filling out the beneficiary on there. So by default, it paid into their estate, which means that it just incurred massive, massive taxes at the time.
Right.
All of the money just has to be withdrawn in one lump sum. And it can lose 30-40% of its value in one fell swoop. That's a terrible outcome. You never want that. So then the second consideration now is if you are naming a beneficiary, the law has now changed as to what different beneficiaries, types of beneficiaries now have different options when they're inheriting a qualified retirement plan like an IRA or a 401k. It used to be, unfortunately, fortunately for people that passed away in the past, you could leave your IRA to a spouse, an adult child, anyone. And when they inherited that, they had the option of keeping it basically intact and rolling it over into their name. And there would be a recalculation done. There's something called a required minimum distribution when you have a 401k or an IRA, which is the required amount of money that you have to start withdrawing. If you're the plan owner, you have to start taking it out at 70 and a half. And then for the rest of your life, you have to take out minimally a little bit of money each year. if someone inherited it from you, a recalculation will be done on that beneficiary's life expectancy. And they, again, would have to start taking out some money right away, but it could be stretched out over the course of their life. So it meant that account sat there growing, tax deferred for many, many, many years. So sometimes we had someone who inherited an IRA from mom or dad, and 30 years later, even though they'd been taking money out the whole time, that IRA was worth even more than it had been when mom or dad died. It was a beautiful thing. Congress took that all away from us. So it was like the biggest tax increase that no one knows about. So now, unfortunately, now instead, what has changed since January, there's only a few beneficiaries. I won't get into the total details of it, but for example, your spouse, you can still leave your IRA to your spouse, and he or she can keep it intact for the rest of their lives. Your adult child or a disabled child can keep it intact for the rest of their lives. If you leave it to a sibling who is within 10 years of your age, they can keep it intact. So things like that. Anyone else, if it's, your mom or dad or my mom or dad leaving it to us, at this point now the rule has changed that no matter what, we have to take all the money out of that retirement plan within 10 years of their date of death. So what you've lost is that lifetime growth in the 401k. So what are considerations? Now that you know that child has to get all of that, if it's a big retirement plan, that child has got to get all of that money out in 10 years' time. Can they handle getting all of that money in 10 years' time? If not, we're going to want to actually, instead of having that retirement plan pay directly to the child, we're going to want to direct it into a trust that is very, very specifically written and designed to receive qualified retirement assets. Because that can kind of control, are they going to blow through all that money in 10 years or is it going to be kept intact? And also, it's meant that sometimes people, if they're really looking to preserve assets, again, because of this new 10-year rule, sometimes they're now working with their financial advisors to explore different options to kind of make up for that loss of future earnings that they would have gotten before.
Right. I want to talk a little bit about gifting, which is sort of tangential to this. But one of the things you see a lot is a grandparent will be transferring assets for the benefit of a grandchild or even a child. And there's this kind of misconception that, well, there's this $15,000 or whatever dollar exclusion, where if it's over that threshold, I've got to file a gift tax return. And I think a lot of people think that means that there's gift tax payable. And I think it actually stops a lot of people from contributing more to a grandchild's education, college education expenses or something like that. How does the federal gift tax fit into a typical gifting scheme? And sort of what are the scenarios where you'd actually have to pay any tax here?
Sure. So we're all subject at the federal level to something called the federal gift and estate tax exemption. Okay. So this is a number that has changed over time. Upon Donald Trump taking office and a new Congress, et cetera, several years ago, that gift tax exemption amount was raised significantly. It doubled from where it was over the previous administration. What that number is now is it's 11.58 million, which means that during your life, you can gift away, and they count it combined between what you've given away during life and what's in your estate at death. Any person can give away up to $11.58 million without having to pay an ounce of gift or estate tax, federal estate or gift tax on that. So just like you said, that people get that confused with what's called the annual gift exclusion amount, which is that any of us can give away, and this year changes from year to year, but can give up to $15,000 to as many individuals as we want to. You could give $15,000 away to every citizen in the United States if you wanted to. And you don't have to say a word to the federal government. You don't have to file a return. You don't have to report it. You don't pay tax, nothing. So a 100 millionaire could give away all of his money in 1 year and not even have to report it to the federal government, as long as he was giving it out in those small amounts. And if you're a married couple, grandma and grandpa, they can each give $15,000 to the same person. So grandma and grandpa can give $30,000 to the grandchild and not have to report it anywhere. Technically, if you give $1 more, technically, than $15,000 to that one individual in any given year, you are supposed to file a gift tax return with the federal government. However, as I say to people, it's a zero tax gift return. You're supposed to fess up and admit that you did it. And the government's keeping that on file, because if you're someone who's uber wealthy and is giving away a lot of money over the course of your life, you may be filing a gift tax return every single year, and they're keeping count because they want to see if over the course of your life up to your death, have you crossed that threshold of what you're allowed to give away tax-free.
Right. I guess the only time for 99.999% of people, if this would ever become an issue, would be if they started making these gifts and reducing their exemption, and then theoretically in the future, the exemption were to come back down to where it had historically been. Perhaps then there could be some consequences, but that's about the only scenario I can think of.
That's it. And even that actually is somewhat of an uncertain area of law. There's generally this idea that as long as you did it, if you did it during a year, that it was still under that threshold amount, you're okay. Right. And you may get grandfathered in. But frankly, it's a little bit of an uncertain area of law, and the laws can change in that respect. But that shouldn't mean that people shouldn't engage in gifting, because if it is truly a high net worth individual, then sometimes that's actually a good tax strategy, to give it away during life.
And so you hit on estate tax and inheritance taxes, and there is this federal estate tax, which again, like you said, the exemption is so high it barely ever matters. Many states have an estate tax. My understanding is that New Jersey has repealed their estate tax, but they still have something called an inheritance tax. I know historically estate taxes were something that really drove a lot of estate planning decisions. It doesn't seem like they are anymore. But what is this inheritance tax and how does it work?
Sure. New Jersey is unfortunately one of the, I'm not sure how many states it is across the country, but it's definitely a minority of states still have an inheritance tax. I happen to practice in both Pennsylvania and New Jersey, and both states have it. So it's a big part of unfortunately, it's a big part of my clients' lives. So, but it varies by state. So this is an extremely state-specific area of law. So unlike an estate tax, okay, so when there's two types of death taxes, like you said, estate tax and inheritance tax. Estate tax is always going to be based on the overall size of the estate, and it's going to be a tax applied to a dollar amount above that. Okay, in New Jersey used to have that. In 2018, it was eliminated. So now you could be worth $1 billion in New Jersey, and your heirs might not have to pay any kind of tax at your death. The inheritance tax is not based on the size of the estate. It is based on the relationship of the beneficiaries to the decedent, to the person who died. So beneficiaries in New Jersey, based on their blood relationship to the decedent, are placed into buckets. So you have Class A beneficiaries, Class C beneficiaries. They eliminated Class C. They eliminated Class B. So you've got Class A, Class C, Class D, and Class E. Okay. Class A beneficiaries pay no tax. These are your lineal descendants up and down the line. So grandparent, parent, child, grandchild, as long as you're a lineal descendant, including a stepchild, you're not going to pay any inheritance tax. Your tax rate is 0 in New Jersey. Then Class C beneficiaries are brothers and sisters, siblings, and your daughter-in-law or son-in-law, the spouse of your child. So they have the first $25,000 is exempt that you leave them. And then they pay 11 to 16%, depending on how much money. It's kind of a graduated scale of what they pay on that inheritance. Then every other type of beneficiary, whether it's nieces, nephews, your next door neighbor, your friend from work, whoever it is that's getting it, that's a Class D beneficiary. And they're going to pay between 15 or 16%, again, depending on how much money you leave them. It's 15% on a certain amount, 16% on the other. Then Class C beneficiaries are charities, which don't pay any tax. If you leave something to charity, there's no tax due.
Well, at least they keep it simple.
Yeah. I've got to do something to earn my business. I have to do something.
That's incredible. That's the first scheme like that I've heard of. That's pretty remarkable. Another consideration, I find interesting that I think is probably going to be on the radar for, many of the people looking at our site, is, you have what is called, some people call it long-term care planning. Other people might call it Medicaid planning. It's basically this area, of law, I guess, that involves repositioning, it might involve repositioning your assets or setting up a plan basically to try to qualify for Medicaid sooner in order to get Medicaid to pay for your long-term care costs. I think something like 70% of people today in nursing homes are having their cost of care paid for by Medicaid. But how does that type of planning, fit into the bigger picture of estate planning? Sort of, where is the intersection between Medicaid planning and estate planning, and what else should those people be thinking about when they're doing that?
Sure. I spend a big part of my day thinking about this and counseling my clients about this because of the fact that I practice elder law in addition to doing estate planning. What I'd say, there's a lot of overlap between them, and you'll find practitioners who only do estate planning, and then you'll find some that do both, as we do. So we're always thinking about this. And what I will often say to people is the biggest threat to, you've worked so hard your whole life, you've hung on to some money, you want to leave this, legacy for your children. The biggest threat to that is long-term care. When you're talking upwards of $10,000 to $15,000 a month out of pocket, if you're paying privately, just a few years out of pocket in a nursing home can wipe everything out. So there are some considerations for this. So when we are planning for someone, if I've got, say, an 82-year-old come in who's already experiencing some medical problems, not only are we going to do the wills and the powers of attorney, et cetera, for them, which also become extremely important at that phase of life in your later years, but we're also going to be looking at their assets that they have and talking about the possibility that they might have some unanticipated long-term care costs in the future. Because no one wants to be in a nursing home, but yet every nursing home is full. So it's full of people who didn't want to be there.
Fortunately.
Right. So what we will think about is, for example, we talked about the elective share. This is where an elective share will comes into play. If I've got a married couple coming in here and one spouse who is very, very frail, and we think is most likely going to need long-term care at some point, we want to make sure, because this happens, sometimes the healthy spouse is the one that dies first, unexpectedly. We will sometimes, and explain to the whole family, it's not that healthy spouse doesn't care about the sick spouse, but if you leave everything to your sick spouse, there it goes. It's going to the nursing home. So we'll say, let's minimize the amount going to your sick spouse. Let's put other planning tools in place, make sure that they are set up, so they can get the best quality care that they need. But let's direct the rest of the money to your other heirs, as opposed to that traditional sweetheart will where husband and wife leave everything to each other. So that comes into play. We will take into consideration, same thing, planning for children with special needs. It's heartbreaking when I have elderly folks come in here who have I've had 80-year-olds in here who have a 60-year-old adult disabled child, who's developmentally disabled, who they've been caring for their whole lives, who's not independent. And now they're 80 years old and they're still worrying about their adult child. So we will, again, start talking about what can they do with their money now, actually, instead of just leaving it to them at death. Maybe we want to put some money aside for that child now in a special needs trust, so that before it has been risked, maybe we want to get it out of their name now before we jeopardize it going to a nursing home. So some things, sometimes we talk about gifting. Sometimes someone comes to us with just wanting a will, and they walk out of here with not just a will, but we've also taken their house, which is their biggest asset, paid off, protected, and we've put it into a trust now while they're alive. Because they're going to live in that house for the rest of their lives, but we want to maybe start shifting assets out of their name to do what's called Medicaid planning. And if you do that far enough ahead of time and it's well planned, you can avoid it getting taken by the nursing home or being lost to your long-term care costs.
Right. And, it's an interesting point you touched on about, not making this assumption that the frail or sickly spouse is going to die first. I think people routinely fail to plan around that. I actually saw a statistic in one of these journal articles the other day. I don't know if it was accurate or not, but they said that actually about 30% of the time, the healthy spouse actually passes away first. They think in large part because, it's such the amount of stress on them.
I was going to say, it's the caregiver burden is very real, is very, very real. So yeah, I'm not surprised to hear that.
So We talked about, we've gone into planning pretty in depth here, and obviously we can design these complex plans, whether it's an estate plan or Medicaid planning, oftentimes require us taking steps to be carried out over a period of many years, especially with Medicaid planning, where it might be a 5-year plan to accomplish it. And I think one of the most overlooked documents in an estate plan is a power of attorney. I mean, you'll hear someone say, "Oh, I don't need a power of attorney. I found one on the internet."
Yes.
and
people come into my office all the time and they say, "Oh, I already have one," and I say, "Hand it over. Let me see it." And it's they got it at Office Max. So.
Yeah, or it's a power of attorney drafted by a general practitioner or attorney. And they got it on the internet.
Exactly. Yes, they don't do that a lot. So they Google it. Yeah.
And so but this is an incredibly crucial document. Many people eventually become mentally incapacitated, and some of this planning and many of these decisions that a person makes in their life that's in this situation are actually going to be made by a third party. It's going to be made by who they designate as their power of attorney. And just thinking, as you were going through that before I was picturing sort of this typical client that walks in your office, and I'm imagining a person who comes in and says, I'm 70 years old, I just got diagnosed with Alzheimer's. So it's like, well, this person might very well have 5 or 10 years before they get to the level where they even need this planning or they need long-term care. But then somewhere along the way, they might not be able to make their own financial decisions. And so I just wonder if you could talk a little bit about power of attorneys and what are the important considerations there?
Yeah, absolutely, without question. Anyone who is kind of marching towards their later years, like we all are, one of the most important documents for them to have is a general durable power of attorney. You have your healthcare power of attorney and you have a financial or general durable power of attorney. Both are important, but in many ways, the most important one is the financial one. And that is because the end result, in an elder law office, we always use the example of the stroke because that's the catastrophic thing that happens when you don't expect it. And then you're shot. If it's a massive stroke, and say from that point forward, if the person is unable to speak, is unable to understand, if they don't have something like a general durable power of attorney in place, it means that no one is going to have the authority automatically to get into their bank accounts, to handle legal decisions on their behalf, make decisions for them, sign contracts for them, pay their bills, you name it. The only way that their loved ones can gain the legal authority to do that is they're going to have to go to court and be appointed as the person's legal guardian or conservator. Okay, so a judge is going to be involved. There's going to be a guardian ad litem or a lawyer who's been appointed by the court to represent your loved one. You, as the adult child or the spouse, may or may not get named as the guardian. So again, control. You've totally lost control of that situation. And it's costly. It can cost thousands of dollars to go through a guardianship proceeding. So instead, what I will say to people now, while you know what you want, while you know who the players are in your life, let's talk about if you needed help someday, if you were unable to make your own decisions, who do you trust to do this for you? Who is going to step in and take care of you? Usually it's a spouse if they're both pretty well and independent. And then we'll name a backup, which is often an adult child. That's the most common thing. Sometimes it's multiple adult children. Sometimes they're named in order. Sometimes they're co-powers of attorney, co-agents under the power of attorney. And then another key thing, and people bring this up all the time, there are kind of two flavors to your general durable power of attorney. There is one that is just a general durable power of attorney that goes into effect immediately. And then you have something called a springing power of attorney. I will oftentimes have people in my office that say, listen, I am taking care of myself. I'm fiercely independent. I don't want my child interfering until I have lost it completely. And only if I have like dementia do I want my kids stepping in and doing this. And, can't that be written into the power of attorney? And I say, yes, we can make it a springing power of attorney. And they say, great, that's what I want. And I say, wait a second, let me explain. The point that I try to make to them is, once we've made it a springing power of attorney, it means that the person can't use it until they've brought in outside medical opinions. The child has had to jump through all these hoops to have mom or dad declared incapacitated. And there could be delays. Maybe mom or dad has dementia now, doesn't want to go to the doctor anymore. It can be a real pain in the neck to do this. And what I say to them is, if you don't trust your child now, immediately today, to manage your money for you, why are you going to trust them when you've got dementia 10 years from now, when you have no idea what's going on? Because you should only be naming someone in that role who you're ready to hand the keys over to, someone who is not going to steal for you, is not going to abuse that authority. So it becomes really, really important to pick the right person to be in this role. And once I don't think I've ever had anyone, after I've kind of laid it out to them that way, I don't think I've ever had anyone opt for a springing power of attorney. What's more difficult is when the person just doesn't have, maybe they're not married, they don't have children, and they don't have anyone involved in their life who can take on that role. That's a trickier situation, but it's very case by case.
Yeah. And so, there's the sort of these two documents that you touched on. You have this financial power of attorney. You also have this document that I've seen it called a living will, an advanced directive, a medical power of attorney, a healthcare proxy.
Yeah, many different names, right?
It goes by many names, but essentially, it says who makes your medical decisions for you when you become mentally incapacitated to make those decisions. And the classic case is, if you don't wake up from surgery or you have a stroke, everybody's, these are people's worst nightmare situations. Most of this, I think, is relatively straightforward. And I think everybody knows somebody who's had to make decisions for a parent or a grandparent under a living will. The one scenario I think people have less awareness of, but probably wish they gave more thought to, is sort of this issue surrounding life-saving medical care and particularly life-saving medical care provided once I've passed the point of no return. How does that work? How can that be built into a living will? How can you sort of still control to some degree these medical decisions even after you're really not responsive?
Yeah. So the most common way to do it when you talk about it's kind of has many different names, right? This document. So what in our practice, we call it an advanced directive. Okay. So that has two components of it. So the first half of it is naming who that decision maker would be. So that's a healthcare power of attorney or your healthcare agent. So that's who makes the decisions. And then the second part of it is like what you referred to is the living will. So this is your end of life care instructions. Under the law, okay, in New Jersey, a living will only applies to two, it actually only kicks in two very unique or very specific circumstances. Now, I talk about this as if medical care is black and white, and you and I both know medical care is not black and white. But as much as it can be defined, the two situations are one where you have a terminal condition. So that means that, two doctors have determined that you have a medical condition that is going to result in your death within the span of a year. All right. So medical care is not an exact science. How do they know that this cancer is going to kill me in a year? It's a best guess, but it's basically, you need the consensus of your medical team that no matter what we do, your disease is going to continue to march forward and is going to progress and it's going to result in your death. It's incurable. You're already in that situation. Or scenario two is you have a permanent brain injury and you're in a vegetative state. And the doctors have said you are not going to wake up again, or have told your loved ones you're not going to wake up again. So your living will basically lays out, if I have a terminal condition or I'm in a vegetative state, what sort of life-sustaining measures do I have? Do I want to be put on a ventilator and kept alive? Do I want to have a feeding tube hooked up? If my heart stops, do I want CPR? So on and so forth, okay? So I'll have folks come in and some folks are like, that's it, pull the plug. I don't want to be a vegetable. I don't want to live in that state of mind. They have no qualms at all about saying that. I have other people who say, okay, well, if I'm really not going to get better and if I'm really, I'm not going to wake up again, I don't want to be hooked up to machines. But what if, I'm just kind of stage 2 cancer and I just have an infection and I'm in the hospital or I have a heart attack? Are they not going to, revive me? Or if I'm in a car accident, not that an ambulance crew would ever know this, but, are they not going to, shock me to keep me alive, in the ambulance? And so what I explain to people is these decisions are never taken lightly. In an emergency situation, doctors are always going to they have to do everything they possibly can to save you. So this is really kind of in some kind of like prolonged situation. The family's all been consulted. Your healthcare agent has been consulted. And they've made sure that you really kind of fall into these two things. And what I also say to people is what they have to remember about an advanced directive and living will is, again, this only gets used if you're unable to communicate for yourself. So what I will say to reassure people is so long as you are awake and alert and understand what the doctor is saying, you can wipe all this away and say, doc, do everything for me. I'm not ready to go. Keep me alive, until I'm 120. You can say whatever you want. You can always change it.
Right. I think you make a good point there that people probably overestimate the frequency with which these things are actually used. I mean, the reality of it is the vast majority of your medical care is still going to be controlled by the medical facility you're at. They're not going to risk their licenses because you have some whack for a healthcare representative saying, no, don't give them that medicine. It just doesn't work.
Well, it's, you and I were talking earlier and I mentioned that my husband's an emergency room doctor, and it kind of, I'll be honest, it can kind of be heartbreaking for emergency room doctors is that they'll have sometimes folks come in from, say, a nursing home, and they don't have this document in place. And the doctors have no choice in that situation but to pull out all the stops, do everything they possibly can to keep this 95-year-old woman alive. And it's tough, it's tough on the person. So it is an important document to have, but like I said, doctors err on the side of doing too much, not too little. So that should never be a consideration. But as if I can add to everything too, another reason to have this, we probably have all known someone who's had to make this heartbreaking decision for a parent, a loved one, even a child, to withdraw life support. And I say to people when they're completing this, you are doing a service, you are doing a great thing for your child to put your wishes down on paper. If you really don't want to be kept alive on machines, have that conversation with your son or daughter, put it in writing, because this is the most heartbreaking decision that they're ever going to have to make. So if they know that they're carrying out your wishes, it's just going to ease that burden a little bit more.
Right. That makes sense. So, so we've talked about a lot of different types of fiduciaries here. We have an executor of our estate, potentially a trustee of a trust or multiple trustees, even a power of attorney, a medical power of attorney. We could potentially be ending up here with 4 or 5 different fiduciaries making decisions for us. What are just your sort of generalized recommendations for, picking people for each of these positions? I mean, are there any requisite qualifications or situations where maybe these people that are in your family are not the best choices? Maybe perhaps you want a professional, trustee, or and also, what other considerations are there? Like, do you want somebody? Can you have somebody who's an out-of-state resident?
Right. Yeah. So we spend a huge amount of time counseling people on this, because it is, for some people, it's a very difficult decision to choose who's going to do these different roles. So generally any fiduciary, you're going to want to pick someone who's going to take it seriously. This is regardless of all those titles that you just listed off there, regardless of which one it is. Someone who's organized, diligent, trustworthy, reliable, who cares about you, who knows you, because they shouldn't be substituting their judgment for yours. In any of these situations, they should be trying to put themselves in your shoes. So, however, that being said, you need to think about logistics as well. If it's going to be your executor, it can be someone from anywhere in the country who does it. However, odds are they're going to have to do a lot of stuff local. They may have to sell your house. They may have to get rid of your car, dispose of your household items, etc. If you've got, one child who lives next to you here in New Jersey and the other kid's out in California, if all things being equal, I'm probably going to suggest that you make the New Jersey child. They win the prize. They're probably going to be the ones, to be the executor. When it comes down to healthcare power of attorney and financial power of attorney, same thing. I'll have families in here who have multiple children, and they're very worried about hurting their feelings and ranking one above the other. So we start having conversations about, like, okay, who really has the skill set to deal with this? When we're talking about the healthcare decision, listen, this person is going to have to be dealing with some potential life or death decision-making for you. Right. Are they comfortable in a hospital setting? Are they going to have the strength to make that decision to withdraw life support? Or is this going to haunt them for the rest of their lives? It's a very personal decision. If it's a financial power of attorney, again, You want someone who's going to dot the I's and cross the T's, someone who is going to manage your money, pay your bills on time, definitely someone who's not going to be tempted to misappropriate your money. These are very, very important considerations. I will sometimes have folks who have two children, again, one local, one out of state, but they want them to both be co-agents under the financial power of attorney. And I will say to them, okay, that's fine. Let's make them co-agents. But listen, you don't want, Carol, who lives in Indiana, to have to come to New Jersey every single time you need to do something. Let's make them co-agents, but authorize them to be allowed to work independently. They don't all have to sign up and everything. So you can customize every document to enable that fiduciary person to have the flexibility they need. And then for a trustee, it's really going to depend on the type of trust, how long it's going to be in effect. Is this a special needs trust where the trustee has to make sure they're complying with a whole bunch of statutory requirements and doing reporting to the state and things like that? And if it's a trust, how well does the trustee know the beneficiary? Do they get along? Because you don't want to make a sister trustee for her sister and they hate each other, and she's never going to give her any money because got it now. So there's a lot of different considerations that go into it.
Yeah. It's and those are obviously difficult decisions, and I'm just thinking of, there's probably a lot of situations where your favorite child is not necessarily the one best suited to be making your financial decisions, or perhaps it's your medical decisions. So you really have to sort of be level-headed about this. And I think a trusted advisor in making these decisions is helpful as well.
Yeah, absolutely. Yeah, and that's it too. And again, when it comes down to being a trustee, if we're talking a significant amount of money, there are absolutely professional trustees out there that this is their bread and butter. This is what they do. And so then, when you fall into a category where you're talking about needing financial management and, investments and things like that, it's going to cost a little bit more, but it may be worthwhile for you to have an independent third-party corporate trustee who's managing things so that, your adult children are not bickering with each other over who's in control.
Right. I know there, it seems like the thing that comes up, everybody's heard these horror stories about these corporate trustees with these set fee schedules, where they charge, frankly, sometimes we'll have a fee set as a percentage of the estate for filling out a particular form or taking a particular step. And sometimes because of the size of an estate, it can become a relatively substantial sum of money. Is that something that somebody can go in while they're still alive and negotiate that and sort of carve out, or can you find perhaps a professional trustee who's more of a boutique trustee, that where they can sort of find a relationship there that they're actually comfortable with and they know they're not going to be losing sleep over that issue?
Yeah. So again, this is going to vary a lot depending on the state, on the location where the trustee is located. It's going to vary based on exactly like you said, what type of trustee they are. It's going to vary based on whether they are also managing the money or are they actually just managing the trust and making the decision-making of the trust versus are they hiring, a Morgan Stanley advisor to manage the money. There is definitely, when you are engaging with corporate trustee, you want to ask them up front to be very transparent, give them their fee sheet, everything that's involved, because just like you said, there are a ton of hidden fees. So it's something that you definitely want to scrutinize. I don't know how much negotiating power you're always going to have in certain situations, but at least you compare different options and you get a feel for what sort of situations are out there. You can make an informed decision.
Yeah. One thing I've heard, and I don't know if you've seen this, but one thing I've heard people mention is that you can always designate a professional trustee and then perhaps designate a couple of them in succession with the ability to remove and get to the next. And I have seen people, use that as leverage to negotiate the relationship because at that point they actually have a pretty significant incentive to work with you. So, it sounds like, like all these situations, it's going to be fact specific. Exactly. And, I would say, this has been great. I think, if I were to try to sum this up here, the first takeaway I have is that there's a lot of considerations. There's a lot of these sort of parallel universes of issues that people are dealing with at this stage of life that they should be that they need to be thinking about. And it's, it's a combination of, your will and your trust to make sure that your assets are going where you want them to go and with the timing that you want. And then you have, this sort of, planning for incapacity and making sure that you have appropriate documents in place to have your financial and medical decisions made. And then, of course, you have these tangential considerations. We discussed many of them, including, Medicaid planning. And then lastly, even with a perfect plan, you've got to make sure you pick the right people to implement it and carry it out.
That's right. Yeah, that's a great summary. Absolutely.
Yeah. Well, and Joellen, thank you so much for taking the time to go through all these questions with me. I found this very informative. I think that the users of our site will as well. I really appreciate your time.
Great. It was my pleasure. I enjoyed it.
All right, take care.